this interaction between justices and private sector special interests is an area that merits much, much effort. And to the point of this being a bad day for the court, I'm no fan of the leak, but I think the bad day for the court was primarily its apparent destruction unilaterally of a 50-year-old precedent on which Americans have come to rely, largely because they were picked to do just that. So that's, to me, the real tragedy here. Senator Lee.
Thank you, Mr. Chairman. It's important to remember the unique role that our court system and the Supreme Court of the United States in particular plays within our constitutional framework. The Supreme Court is there not to decide matters of public policy according to public will. It is there to exercise judgment, to interpret provisions of federal law, whether part of a statute or the Constitution, when multiple parties properly before the jurisdiction of the courts disagree as to the meaning of the provision in question. It's why we give them lifetime tenure. It's why the Supreme Court and the other federal judges within our system operate with life tenure, subject only to impeachment and removal. It's because we don't want their decisions to be influenced by political agendas. That's the whole reason they're there. There have been times in our history when, tragically, we've veered from this vision. And when the courts have been used, I would say abused, in order to pursue a particular political outcome. It doesn't always take the same political direction. It doesn't always favor one side or the other. I can point to an instance, for example, in 1905, when the Supreme Court of the United States engaged in what I would regard as political maneuvering, invalidating a law duly enacted by the state legislature of New York to undo legislation prescribing minimum wage measures and maximum hour provisions on workers at bakeries. The Supreme Court concluded, in essence, this is important. It's important that individuals have the ability to contract with their employer. It's so important, in fact, that it must be in the Constitution. We deem it to be so. The name of the case was Lochner versus New York. It remained intact for 32 years. It was, in my view, some disagree with me, but it was, in my view, an act of judicial aggression into the political realm. The fact that it was 32 years old by the time the Supreme Court issued a ruling 32 years later in a case called West Coast Hotel versus Parrish didn't make it impervious to review and reexamination. To the contrary, it was high time that the court revisit that. So I don't understand why on this committee or in this body we should ever be talking about praise for a court that would engage in political manipulation. Now, some who are frustrated by their own attempts to use the court as a legislative superbody, something to put in place policies they favor but have been unable to achieve through the political process, through winning elections. Having secured certain victories in court, then become incensed when the court no longer goes along with them. There were those who were furious in 1937 when the Supreme Court recognized the mistake it had made in 1905. In response to that, some might have tried to delegitimize the court. The court was certainly undergoing a lot of efforts to delegitimize it at the time. It was the same year that Franklin D. Roosevelt threatened to pack the Supreme Court. And although his threat ultimately failed as a legislative matter, it left an unfortunate, indelible mark. Those who are trying to undermine the court are doing grave harm one way or another. This unprecedented treatment of Republican-nominated justices on the Supreme Court, things that include but are not limited to the high-tech lynching of Clarence Thomas when he was before the Judiciary Committee more than 3 decades ago. There are other more recent examples, including Senator Schumer's very public attempt to threaten and intimidate the court in front of the Supreme Court building during oral arguments in the Louisiana abortion case known as June Medical. These and other moves to delegitimize the court are concerning. It also concerns me that this hearing may be more of the same, an effort to delegitimize the court, designed primarily to wage war against conservative justices and against the man that then Chairman Joe Biden failed to destroy in his attempted high-tech lynching of Clarence Thomas 30 years ago. So if today's Democrats can't control Justice Thomas, if their consistent and unrelenting efforts to caricature him have done nothing to intimidate him, then they want to do everything they can to delegitimize him. It worries me greatly that this leak occurred yesterday. This leak, we don't know exactly who did it, but we know that it might easily have been done. One could easily surmise that it could have been done by someone who was upset at the contents of the opinion of the court with Justice Alito's name on it. To the extent this was an effort to threaten, intimidate, and harass those justices inclined to support that opinion, it's disgraceful. It's disgraceful either way. And to suggest that the true injury here is somehow that inflicted by that opinion gets it completely 180 degrees backward. In 1973, the Supreme Court of the United States deviated into an area outside of its jurisdiction, outside of the realm of the Constitution, adopting a policy aim motivated by a political agenda that is nowhere in the Constitution. Those justices, starting with my former boss, Justice Alito, who authored that opinion, and those inclined to join it, should be praised, not condemned and ridiculed. Now, I understand not everyone on this committee is going to agree with my assessment on that, but we should agree with the need to protect and defend the legitimacy of the court, even when we disagree with it, not attack it. And that's what's going on here. Thank you.
Thank you, Senator Lee. We have